morning, everyone. Welcome to the First District Court of Appeals. So we have three cases that were set for argument today. I'm going to read the cases, and if the attorneys would state their names and their readiness to proceed, I'd appreciate it. The first case that is set is case number C-230161, and it's Snyder versus DeGraff and Reed. Is anybody here on that case? I was told nobody showed up. Okay. Okay. All right, so no one showed up for that case. I don't know if we're making some phone calls. We'll see if anybody ends up showing up. The second case is C-220647 and 648 in Ray JP.
Josh Thompson on behalf of the defendant or appellant, ready to proceed, Your Honor.
Good morning.
He's ready to proceed.
Good morning. So you guys will be first up. The third case set for argument is C-230270 in Ray LF.
Good morning, Your Honor. Nicholas Kulik on behalf of the appellant, ready to proceed.
All right.
Good morning, Eric Anderson on behalf of the appellate Seth Franklin.
All right, thank you. All right, so for will the attorneys for in Ray JP come forward? And Mr. Thompson, would you like to reserve some time for rebuttal?
Yes, Your Honor, 3 minutes, please.
3 minutes, okay. I'll use the lights on your podium. The yellow light will come on when you have 1 minute of your initial time to go.
May it please the court, counsel. This is a case that will prove critical to our future understanding of self-defense law in this district. If the juvenile court's decision is affirmed, it will stand for the following propositions. Spreading a rumor earlier in the day makes one equally responsible for creating a situation as someone who comes to your house with a group of people to hurt you and someone who stops a car with the same people later in the day in order to hurt you. A 13-year-old cannot go outside after dark without an adult if someone threatens them earlier in the day. A 13-year-old hiding behind her mother when threatened by a group of people implies the 13-year-old does not believe the threats. Carrying a pocket knife outside the home in the dark after being threatened makes self-defense unavailable. A child cannot carry a knife in self-defense. If someone has a problem with them, they want to solve with violence.
Mr. Thompson, one of the challenges, it seems to me, in this case is that JP never testified. And I'm not aware of too many self-defense cases where the defendant does not testify to make their case of why it was self-defense, particularly when we have disputed facts here. So how do you overcome that?
Well, ultimately, there is evidence clearly tending to show that JP acted in self-defense, that multiple people approached her after stopping a car. And
well, see, that's what I'm not clear on. And I mean, this isn't a situation like where we've got video evidence so we can see what happened. It sounds like there's some inconsistency in the testimony based on what I understand, and correct me if I'm wrong, as to whether everyone immediately exited the car and approached her in a combative manner, or if the victim got out of the car and the other people were, I don't know, fumbling with their phones or whatever, and were not out there ready to attack.
Sure. One thing is for sure, it's that NG got there first. Mm-hmm. And it is without question that the car was stopped and did not have to be stopped. Mm-hmm. They were out and JP...
But I think like what this goes to is, did she reasonably fear for safety because she was going to get jumped by multiple people, or was this just a one-on-one fistfight?
Well, the answer to that is yes. She did reasonably fear And it comes with a question of our own, essentially, of how long must one wait to find out if all the people are going to jump you? The reason we know they were going to is because of what they did earlier in the day. To shift back a little bit to the original question, the burden's on the state once the evidence tends to show she acted in self-defense. Even if we were to believe that JP acted with too much force, the simple fact is that car was stopped, didn't have to be stopped, and people came at her. So that's evidence tending to show self-defense. So then it is incumbent on the state to show proof beyond a reasonable doubt that she did not act in self-defense. So in terms of JP needing to testify, I know the court knows full well she doesn't need to testify, but because the burden has shifted to the state, and they do not present nearly enough evidence to disprove the self-defense, that is how we overcome the fact that JP did not testify.
It seemed like, so I see what you're saying about who started it.
Mm-hmm.
Maybe the judge was not with the record on that one. But it seems like one of the things that the judge said was that she did not have a fear of serious bodily harm because this was just supposed to be a fist fight. Can you kind of address what the serious bodily harm piece of it? Because that's what you need to use deadly force.
Well, the answer to that is also twofold. I think, one, I feel that the juvenile court failed to view this from the lens of a 13-year-old girl, because it doesn't just have to be that serious physical harm could happen, but a bona fide belief that it could happen. And this is a 13-year-old girl who's been threatened earlier in the day by a group of people who came to her house, who stopped a car and came at her. So her fear is bona fide in this situation. They've got a car, they stop in the middle of the road and turn around.
But I'm talking about bodily harm versus serious bodily harm.
Okay.
Because it seems like the judge is just focusing on the fact that this was supposed to be a fist fight. And can you reasonably fear serious bodily harm if you're going to just have a fist fight?
Well, I think that the court's finding that this was just a fist fight was misguided, first of all.
Okay.
There was some text messages between the moms and statements by JP's mother at the scene that she offered a one-on-one fist fight. That was never accepted. There's no real evidence that that was communicated to JP, and she clearly wasn't interested. She hid. She stayed behind her mom. So the question then is, 4 people, at least, that we know about were in this car. We know one was an adult, and we know one was male. And we know that the rest were either JP's age or a little older, or I think the male might have been a little younger. 4 people coming at you has to be.
Well, but I think this gets back to my question, like, were those 4 people coming at her or not? And were those 4 people threatening serious bodily harm? Did they have a weapon? Are there any other indicia that would have made this response reasonable? Because the concern that I have, I hear what you're saying, but in these self-defense cases, like, are we essentially just condoning the Wild West in violence? And sometimes it seems like we're getting kind of close to that with the stand your ground law and some of those attributes. But generally, like, there needs to be some objective indication that this is a real risk to justify deadly use of force.
Okay. First of all, the follow-through, the threat earlier and the follow-through later, that indicates a level of seriousness than perhaps something more impromptu. The car, there's a car that could be a deadly weapon. I know that wasn't necessarily the argument, but there is a car there. There is an adult, there is a male, and 4 people. Serious physical harm. There are numerous felonious assault cases, fist fights, endlessly, of one-on-one, let alone 4-on-1.
Let me ask you, Mr. Thompson, my understanding of reading of the transcript was that wasn't much of a fight. The decedent walked up, or had her phone, apparently called her mother, threw it down, walked up and kind of squared up with your client. And I don't, at least my understanding, she didn't even throw a punch, and your client cut her from her ear down to her throat, right? So there was it really wasn't a fight.
It was, the question
I mean,
isn't
the fight
whether-
never started.
Sure,
Yeah.
well, the question isn't whether she was in a fight or had been hit. It is whether she feared imminent great bodily harm or death. And I think that it is incumbent on the court to find that 4 people coming at you following through on threats they made earlier in the day is too many.
So
One on-
it's the number, is
It
what
is
you're
the
saying.
number.
It's not necessary. If it were a one-on-one fist fight, that's very different than the number of people that you're saying were coming toward her.
Correct. I think that is the truly distinguishing factor here.
Can I ask you a question on the record, though? The record seems to indicate that JP also had some people with her.
We know for sure she had her cousin, at least.
Okay. So does that make a difference, that she wasn't alone?
If those people were involved in the fight, I think it would make a difference.
Can we infer that they might come to her aid? I mean, she's not by herself.
No, I don't think we can, because it's the state's burden, and they've not put on any evidence that the people with JP came along with her. All the evidence, as far as we know, is they stayed away. Their own witnesses came forward and said, no, we came out at her. It might have been in some order based on how long it took to get out of the car. We know that MG was in tow because we know he followed JP all the way home and apparently pushed her and hit her. So we cannot infer that the group, without any evidence of all, would have or could have helped in this scenario. Are there any further questions on the manifest weight argument? Okay. There's an additional question here that does play into the manifest weight argument, and that is the expert testimony in our second assignment of error. The state or the defense in this case wished to put on a defense expert who would testify to brain science, essentially, to the capabilities of JP to analyze this situation as a 13-year-old girl in her particular scenario.
Yeah, and let me ask you, I read the report, and a lot of it seems to be kind of basic information that I believe a juvenile court judge would be well acquainted with. So what from your perspective is the most critical aspect of her testimony that would have been most helpful to you all?
Well, ultimately, the lens, the subjective nature of the self-defense claim that her fear was subjectively true or subjectively bona fide, because all of the court's decision in this case comes from an adult lens. It doesn't really come from JP's lens. What is she viewing in this scenario? How much does she fear? You're supposed to stay inside. Juveniles aren't supposed to defend themselves. Juveniles shouldn't solve problems with fights. But the question is, does JP have the capacity to analyze this situation correctly? And what lens does she use? And that is where Dr. Dieters could have been of significant help to present the defense theory that JP would have been more fearful than an adult and would not have been able to analyze the situation as thoroughly as an adult. I don't see a light, but I think I might be.
Yeah, you are at your initial time if you want
I'll
to
reserve the
3.
remainder of my time.
Okay.
Thank you.
Are the lights not working on the podium?
Not the red light, at least.
Oh, okay. Well, that's not helpful.
Good morning, Your Honors.
Morning.
May it please the court, counsel, just a few brief points, really. I don't have a lot to add to what's in my brief, but I would just note as an overarching theme of this is that this is a bench trial. I think we have to look at it through, look at the entire case through that lens, if you will. As for the first assignment of error, there was some question today about the sufficiency of the state's evidence to rebut self-defense, but I would note that in the appellant's brief, it's a manifest weight of evidence case. That's how they've framed the assignment of error. And I think that if we look at this under that standard of review, the trial court did not clearly lose its way in this case.
Well, Mr. Sauer, let me ask you about the decision, the aspect of the trial court's decision that JP was at fault for this affray, because I had real difficulty understanding that, because I think what she was saying is like the spreading of the rumor then, sets this whole ball in motion, but ultimately precludes her from defending herself when she's attacked, and that just was problematic.
I agree, Your Honor, and I think if we were relying solely on the fault prong of the self-defense test, we would have a lot tougher case here. The trial court, in a way, seemed to adopt some of the civil law standard for proximate cause or
Right.
something like that. But I think that in light of the other factors that the state disproved, I think that was any comment on the fault aspect was harmless beyond a reasonable doubt. There was at least some evidence in the record that this was going to be a one-on-one fight. There was at least some evidence in the record that that's how it was playing out, that NG approached JP alone. And as a finding of fact, I don't think we can say that was clearly erroneous.
And none of the person or people with JP testify, is that right?
The people with JP, I don't think the cousin did testify in this case, but I think.
Well, there was also some maybe discrepancy in the record whether there was just the cousin or whether there was a couple of other people.
Right. She was walking her cousin somewhere to the curb or home or something like that, but it wasn't entirely clear from my reading of the transcript that who else was there.
Right.
Eventually, once the stabbing had occurred and the emergency personnel were there were numerous people, a huge crowd, but
But in other words, whoever was there didn't testify.
Exactly. Okay. Right. Exactly. It was another. I don't know who it was. Even it was a cousin. But other than that, I don't think it's clear from the record what role that cousin played. As to the report of Dr. Dieters in this case, I think
Before you move on to the expert report, the judge also seemed to make some sort of finding that this was like supposed to be, and you even said this was supposed to be a one-on-one, or she said something about a arranged fight. And I guess the way I looked at or read the record was you had a bunch of people trying to fight JP early on. She cowered behind her mother. They said, "We'll get you next time," or something. And then they're driving past her. They weren't scheduled to fight that night,
No,
right?
it wasn't like a
Yeah, and they
boxing
turned the
match,
car
exactly.
around when they saw her, right?
exactly.
So how do you respond to the serious physical harm argument where this wasn't just a fist fight, this was going to be multiple people fighting JP?
Well, the way I would respond is, first of all, there was some indication that it was going to be a one-on-one fight because there had been discussions about that, and I think that's what the trial court was relying on. It might have been discussions between the two mothers or between the different factions on that day. So I think there was some indication it was going to be a one-on-one fight, and in any event, that's the way it was playing out on the night of. There was one person who approached the defendant in this case, and she immediately, instead of fighting, stabbed her in the neck. And I think that finding of fact is clear in the record and that it's virtually undisputed.
But she also, we're looking at her mindset at the time, JP's mindset, where she sees a car full of people stop and then multiple people are like coming toward her. And so, what was her mindset at the time as far as what kind of fight this was going to be?
First of all, I think there's no indication how many people were in the car, who was in the car, and there was
There were three people?
There were, yeah.
Okay.
But there was also three in addition to NG in this case, correct?
So it would have been four people coming toward her.
It was if they had been coming toward her, but there was some conflict in the testimony about the timing of when they got out of the car. It's not clear where those other three people were at the time the stabbing occurred, for one thing. And that goes to Judge Bergeron's point about the lack of testimony on the part of JP to say, look, it wasn't just NG approaching me at that time. All three of these people piled out of the car at the same time and were approaching me. That's not what the
That
evidence...
would make a difference in your mind?
It would definitely make a difference, and that's not what we have. And the findings of fact that the trial court made did not indicate that that's what we have here. And I don't think we can say that that finding was clearly, contrary to the evidence, or, was so that the trial court lost its way in making that finding.
And when, I was going to ask, like, when we are looking at manifest weight for a bench trial, with a jury, we never get reasons for why they do what they do. And
Right.
now we have a full opinion.
Right.
How are we to evaluate this? I mean, do we kind of just look at it fresh without even looking at the judge's findings? Or,
Well, I think we have to, I think we do look at the judge's findings and to determine whether or not the trial court lost its way. And I think its discussion of the evidence as presented at trial indicates that she did not, the trial court did not clearly lose its way, because everything she said was, there was at least some evidence in the record to
well,
support.
not with who started it. You would agree that one?
I think that's the shakiest part of it, Your
Yeah.
Honor, but I think that, I do understand where the court was coming from in that, whether it was legally justified, or her findings were legally justified or not. I understand what she's saying, but I think that the findings with respect to the other prongs of self-defense were clearly supported by the record, and we can't say that the trial court clearly lost its way in making the adjudication in this case. With respect to the report of Dr. Dieters, I think that again, what the trial court itself said with respect to this evidence was that the trial court had the expertise to make this determination. There's certainly no abuse of discretion in the trial court's finding that the purported or the proffered evidence would not be helpful to her in deciding the issues of the case. And I don't think there's any basis upon which to make a reversal on that score.
So we're looking at this more from the sense that we're dealing with a juvenile court judge, and we assume that juvenile court judges know all this stuff. I mean, is that how we're supposed to evaluate this? 'Cause I thought it was helpful to a trier of fact in general.
I think if this had been a jury trial, it might be a closer case. I
Okay.
still don't think it would be an abuse of discretion, but I think it would be a closer case. But when you have the trier of fact itself or herself stating on the record that she has this expertise and that the proffered evidence would not be helpful to her in deciding the issues, I think that's virtually conclusive as to this assignment of error.
Right, so we have a juvenile court judge that says that she understands juveniles' brains.
Right. So I don't think it would add anything. And I certainly don't think there's an abuse of discretion in her keeping this out of evidence. Mr. Thompson did not address the third assignment of error, so I'm not going to do that. I don't want to step on his
Well,
toes.
can I ask this one question about that? Is there any conclusive evidence that video was made the night of the fight? I mean, because in my mind, if it's made the night of, very probative. If it's not made the night of, very problematic.
Right.
And so what is the state's position?
No, I don't think there's any conclusive evidence, but I think the question that the court's faced with here is authentication under Rule 901, and I don't think there has to be conclusive evidence that it was what it purported to be. There's at least some evidence that this thing was posted tonight, and given the proximity of the statements made in that to what happened during the night, I think that's at least something that would tie it to the events of this night. But even if there weren't, I understand your comment that it was problematic. I would respectfully disagree. I think in this case, the trial court, when the trial court admitted the video into evidence, said, "I'm going to accept it for what it's worth," essentially, and in her written opinion, apparently didn't find it was worth anything because she didn't mention it. I think this is a very, very weak case of self-defense, given the uncontradicted facts, and I just don't think that the video played any part in the
You're saying it's
adjudication.
harmless?
Beyond a reasonable doubt, yes. Unless the panel has any more questions, I would just ask the court to affirm the judgment.
Thank you.
Thank you very much.
Mr. Thompson, you have 3 minutes.
One thing I'd like to point out about the video from the incident earlier in the day is that they said they were going to get an aunt or an aunt in the video, and then they left. And that was made, that JP presumably knew that because they said it out loud at the scene. So they leave, and it's later in the night, and they come back, and that's when there's a car and an adult there. But even if we were to assume that this was supposed to be a one-on-one, it's not what happened. JP, if they're supposed to be a one-on-one, doesn't know she's going to a fight. She's walking her cousin home, and they show up with 4 people, including an adult and a male. So any idea that this was a one-on-one is irrelevant to the analysis of what actually happened in this case.
Well, what about the idea that the other people weren't there immediately? The victim got there first and the other people were behind. Apparently that was the facts. They didn't all show up together.
Right. Well, they did all show up together because they all came in the same car. It's inherent in the nature of a car. There will be different exits. But JP would have to be a very quick-witted adult to analyze this situation as somehow different. Like she's supposed to wait for 4 people to show up and see how this plays out? Or does she see 4 people hopping out of a car who threatened her earlier and reacts to that? Who gets there in
But
what
this
order?
then gets to my Wild West point. Like, what if she had had a gun and just like opened fire on all of them? I mean, from your rationale, like that would have been appropriate.
Well, I don't make the laws. The stand your ground is a thing in this state, but the counterpoint to that would be that it's the Wild West, that you can show up and threaten to beat people up and not have someone defend themselves against you.
Well, with deadly force here. I mean, she could
One-on-one,
have engaged in a
no.
fist fight with them.
Well, one-on-one, no obvious weapons, maybe a different story. 4-on-1, and a car, and an adult, and a male, very different story.
You keep talking about a car, and there's
Sure.
really no evidence on the record that this car was being threatened to be used as a weapon.
Well, there is evidence it was there. These are all things that play into the mindset of a child.
Was there evidence that it was pointing at her and there was somebody in the driver's seat? Are you talking about like
There's
running her
evidence
over?
it drove past and had to turn around. There was also some evidence that they knew what they did was wrong because they told conflicting stories about what they were doing, turning around for fixing glasses, for instance. That's not what they were doing. They were allegedly going to Gold Star, but the evidence really showed they were out looking for JP. The one thing on the video, the prior video before the murder, the state said it wasn't relevant and then presented it as substantive character evidence that JP did exactly what she said she was going to do that night. I don't know how the state can do both things.
But even if that's a problem, how is the judge didn't even mention the video in her decision, so it doesn't even seem like it had any effect.
Well, I think the judge said you can't bring a knife out, you can't arm yourself with a knife to defend yourself. So I think the hints of that do show up in the decision, in the analysis of the knife.
You are at your time. So.
Thank you, Your Honor.
Thank you. All right. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision.
Thank you, Your Honor.
Thank you. All right, the next case is In Re LF. Yeah. We'll just announce that at the end. Mr. Kulik, would you like to reserve some rebuttal time?
Yes, Your Honor, I would like to reserve 3 minutes.
3 minutes, all right. I'm using the lights, but apparently the red one doesn't work, so look for the yellow one and you'll have a minute left.
Good morning, Your Honors. May it please the court. The appellant, mother, Julie McIntosh, is respectfully requesting this court to overturn the judicial entry that designated the father, Seth Franklin, as the legal custodian, reinstate her as the legal custodian of the child, grant parenting time to father, and overturn the decision to find the mother in contempt for denial of parenting time. This court abuses its discretion by failing to follow a sound reasoning process when making its decision. Typically, when you fail to follow a sound reasoning process, you have the law of the case and case law in the state of Ohio. You apply the facts of evidence.
Well, let me ask you about that, because as I'm reading your brief, I don't see any citations to the record, and our rules require citations to the record for factual matters so that we can analyze the facts. And we don't have that here, so how are we supposed to figure out whether or not the trial court got it wrong from a factual perspective?
You can look at the judicial decision and the magistrate's decision that made findings of fact.
Right, but then like we have to have something to compare that to if we're going to agree with you. And that's the appellant's burden, is to say, well, the court made these findings of fact, but look at what the record shows. And that's what we're missing here, what the record shows.
And then in the brief, I do cite to the facts in the transcript.
Right, but you don't tell us where that is. So like what are we supposed to do with that?
You can compare the facts that I cite in my brief to what I cite to in the decision of the facts that they made. Here, the court abused its discretion in finding mother in contempt of a parenting time. In order to find...
Before you do that, was the contempt purged?
Yes, that's correct.
Okay, so is this issue moot now?
I don't believe it is, because it's certainly something that the court relies on heavily to grant father legal custodian. A statutory factor for custody is whether or not you're going to adhere to any court order, specifically here a parenting time schedule, and the court does find that mother, largely based on the contempt finding, it fails that statutory factor, then gives father custody.
Okay. So, I mean, but the case law does say that once the contempt is purged, it is moot. The issue is moot.
The finding of contempt may be purged, but the issue certainly is a significant issue in this case. And any case that you're going to change custody, whether or not you're going to adhere to the parenting time schedule, and the trial court and juvenile cases largely rely on that statutory factor when there is also a combined contempt motion for denial of parenting time.
Okay.
And also the finding of her contempt, to begin with, was not substantiated by any court order. So you need a valid current court order to find an individual in contempt of court. The decisions don't cite to any valid court order at the time. In this case, started by a filing of father in late 2020 for a change of custody, and then mother filed the motion in the first week of January to suspend father's parenting time. It was indicated on November 20th, 2020, that the child indicated to mother that there was bruising on her stomach and a rash near her vaginal region. Mother called Children's Services and filed a motion after she retained counsel to stop parenting time and investigate what was going on. She was very concerned that her little child may have been getting abused in father's care when he had overnight parenting time. At that first hearing in juvenile court in Hamilton County on January 28th, 2021, the court agreed with mother to suspend parenting time to investigate. Parenting time was stopped, overnight unsupervised parenting time was stopped, and then the court ordered parenting time as a visitation center, now at Best Point, formerly known as Children's Home. As the case went on, new orders, interim orders were made for parenting time, and mother followed all of them. In fact, this case went on for a few years, and mother started to allow parenting time for father that was even not court ordered, that the attorneys were able to discuss and agree to. The court didn't cite to one and can't because there's no valid court order that mom ever violated. The court...
And there was no penalty for the contempt finding, right? Because my recollection is the order that said you're in contempt says the contempt is purged. Is that right?
Correct. Well, it was purged because mom was providing parenting time. We eventually went back to an every other weekend parenting time schedule, which was the court order from September 2019. And so that's why it was purged, because mom was providing parenting time.
But I mean, there was no like finding of any sort of monetary sanction or anything like that in conjunction with the contempt.
You're correct. There was no monetary or jail time imposed by the court. They just found her in contempt and then indicated that it was purged because she already previously provided parenting time.
So the first assignment of error is moot because of that, right? So we're really just focusing on the second assignment of error here, on the change in circumstances issue?
Yeah, I would focus the first one on the issue, the factual circumstances that the court found her in contempt, because those are very important in this case. If the court does not find her in contempt and makes the finding that she unreasonably denied father parenting time, she doesn't lose custody.
But what are we gonna do with that? If it's purged, if it's moot, we can't, there's nothing we can do on assignment of error one.
I think you can overturn the decision that found her in contempt.
Okay.
And then what happens? We overturn it, so.
You would
It's already
remand
been
it back
purged.
down to the juvenile court, and if there's no finding of contempt, father's case, in my opinion, goes away, because the whole case is based on her unreasonably denying parenting time. If that's,
Well, but that's why I'm trying to focus you on assignment of error too, because we're talking about your argument about it, that they didn't show a change in circumstances. So explain to me how, I mean, what are you saying the contempt finding is what found the change in circumstances here?
there's two chains of circumstances that the court found. One was they found that mother reasonably denied parenting time to father. The second is that they also rely on feast versus feast. And in that case, it discusses that rancor between the parents or parties, through the legal, between the parties, can rise to a level that would affect the child in such a way that custody could change.
Right.
The problem with relying on that case is the factual circumstances and findings of feast versus feast are nothing like this case here. The first reason is that the mother who lost custody to father in that case was previously found in contempt before that trial instituted. So there was a finding that mother consistently denied parenting time to father and was found in contempt for that. So the court found that she's continuously trying to do that, and the court found that. The second is that the court had to order therapy for both of the teenage children in that case, because the communication between the parents that they largely put on mother was so bad that the children's development and well-being was to the point where they need to go seek therapy.
There was information in the record, though, that the difficult relationship between mom and dad did affect the child in this case, right?
There was a finding of the court. However, mother's position is that that's exaggerated. It's not based on any facts of the case. In fact, the court actually, in its decision, also states how well the child was doing, getting good grades, there's no health issues, well bonded with the father. I mean, all of these things that would suggest that mother was doing the right things with the child, not creating an atmosphere where the child was doing wrong. Also, the child who mother voluntarily brought the child to a Dr. Vicki Reynolds for therapy to just make sure the child is okay and can express herself if anything was going wrong that she needed to talk about. And that doctor testified in court saying that the child was doing very well and that she didn't have to continue to see the child because the child was such in a good mental well
So
state.
the findings of the court, just so I understand, where during a visit with father, the child said, "Mommy doesn't like you, so I don't like you." Is your argument that that is not?
The child
correct
did say
finding?
that, but that is the only evidence that the court has, that at the first supervised visit in children's home, the child, who's very young, states that mommy doesn't like you, so I don't like you. But then when the guardian ad litem observed the child had an amazing relationship with dad at dad's home. So that one statement is pulled from the visitation report, and the court sits on it and says that mom has caused this horrible relationship, where no other evidence that was presented at trial would suggest that. In fact, it suggests the opposite.
That a former babysitter indicated that mom sort of had poisoned the well with the child regarding the relationship with the father. So there is some other evidence of that.
And I would ask this court to hold very low weight to the testimony, well, not testimony, statements made to the guardian ad litem. The babysitter never testified in court, never provided a written statement, and the only evidence on the record is through the guardian ad litem report that the guardian had with that babysitter that was fired by my client. So she had some reason to speak negatively about my client.
The judge is finding this credible, and we are looking at whether or not the judge abused his discretion here, right? So we're not going to make credibility findings, right?
I believe that they abused their discretion by giving the weight that it did. And you can make that finding, that babysitter never testified in court, never made a written statement, and the only other thing that they rely on is a little kid's statement that they made in the first children's home visit. All the other evidence that was presented at trial says that they have a great bond together. So if they don't, then that statutory factor has got to be changed because they say how great the bond is. And that's one of the reasons why dad gets custody.
So in your mind, when we would look at the relationship having an effect on the child, it would have to be a really severe effect, almost to the point where the child would need therapy.
Correct, and that's the finding of fees versus fees that the court relies on.
Okay.
I would like to reserve any additional time.
Okay.
Thank you.
You have 3.5 minutes.
Good morning. If it may please the court and opposing counsel, my name is Eric Anderson. I represent the appellee Seth Franklin in this matter, and we would ask the court, the appeals court, to affirm the judge's decision granting custody to my client, Mr. Franklin, along with the parenting time that was awarded to mother Julie McIntosh. The court has been talked about, and as you know, deals with this matter in an abuse of discretion, finding whether the court had reasonable, or I guess if the court's decision was unreasonable or arbitrary or unconscionable, there was no sound reasoning process, then you could find an abuse of discretion. In this matter, the court has used a sound and reasonable reasoning process. We had to begin with an investigation over the length of the time by the guardian ad litem, who was brought on to represent the best interests of the child, who talked to witnesses, talked to the counselor that was involved with the child for a moment, talked to the parents, both parents, and she came up with a decision. The court saw that, and not only the magistrate, but then the trial court found that there was a change in circumstances, that there was a material adverse effect on the child LF, that the acrimony between mother and father had risen to a level that there was an effect on the child. First of all, there was a time
and again, this ties into my question to your opposing counsel here, but I also don't see any citations to the record in your brief to show us where in the record all of this happened. And so, like, what are we supposed to do with that? Like, are we just supposed to, like, hunt through the record and try to substantiate this, or?
No. I guess looking through the judge's decision and through the briefs, Your Honor.
Well, right, but the problem is, we have the judge's decision.
Yes.
You're saying it's correct based on the evidence. He's saying it's incorrect based on the evidence, but neither one of you is showing us where that evidence is in the record to enable us to figure out whether the trial court abuses discretion or not.
I understand that. You're correct, Your Honor. You're correct. The guardian ad litem pointed out that there was a failure of the mother to notify father on important health decisions. To begin with, the child had a tonsillectomy towards the end of November of the year prior to the trial, which would have been, I think, 2022, and mother didn't notify father until after the procedures happened. Then she notified father that, well, he couldn't come to the hospital room because the hospital's rules were that there wouldn't be enough people involved. And Mr. Franklin found out that he could have been there, that they had enough room for him to be there. And then also, the child had some complications and some bleeding after the tonsillectomy, and Mr. Franklin was not made aware of that. There was, as the court.
Are you
and the
saying
guardian
that's an
pointed out-
adverse effect on the child?
Pardon me?
Are you saying that amounts to an adverse effect on the child?
Yes, I am. Yes, I
Okay.
am. Yes, I am.
And how so in that instance?
It could be argued that she was denied the ability to be with a parent that she was closely bonded to in a time where she was in an unfamiliar place, the hospital, and had been going through a procedure that had to have a little bit of traumatic effect to her, knowing that she was ill, that she had to go back to the hospital, that it was bleeding. It would have been nice for the child to have been able to have both parents there, and the father who she was bonded with also.
For emotional support, but we're not talking about that the mother did anything to cause father to miss medical appointments for this child or anything. I mean, the child missed going to the doctor or didn't get medical treatment.
It was emotional. The mother did not make father aware of the tonsillectomy prior to it being happened. She told him after the child was already in the hospital. There was also, as we'll point out, one of the supervised visits at Best Point where the child spoke directly to Dad and said, "Mommy does not like you, so I do not like you." And as the trial court and the guardian ad litem pointed out, this poison of the well, as you spoke to, Your Honor, mother didn't do anything to alleviate it, and there's evidence there that she created that. The child, LF, did not feel free to talk to everybody about all the issues in her life. She was somewhat guarded, and it was pointed out that the babysitter had been fired. Well, there was a dispute, and I understand your previous question, but there was a dispute as to whether the babysitter terminated the relationship or whether she was fired. And the babysitter did come forward, admittedly, right prior to the initial court date to tell the guardian ad litem what she had seen, and that certainly was an integral part of changing the guardian ad litem's initial recommendation to recommendation for the father. Her initial recommendation was a little bit on the wishy-washy side in that I don't see a change in circumstances yet, but if you do this again, Mother, I'm going to change my decision.
Here's the question I have, and this is what opposing counsel has brought up. There were these references the child made. Mommy doesn't like you, so I don't like you. But apparently the record shows that it didn't matter because the child had a really good relationship with father anyway. And so that's very different than the other case that I think it was the Fissy case that was cited, where the children had to actually go to therapy. So we know for a fact that there was an adverse effect on the relationship due to the fighting of the parents, versus in this case, the child might have made some comments, but ultimately, apparently, the relationship was good.
Which is to speak to the father's ability to do the best he could in that circumstance, and that maybe looks more to the good of the father in the relationship as opposed to negating what the mother did. I mean, you'll also see that there were 2 CPS investigation referrals made, one in, I believe, Warren County, the other in Hamilton County. When the child was going to her counselor, the counselor was under the impression from talking to mother that this new case was new facts, when the new case in Hamilton County was just the same case from the same date, now in a different county, which led to the judge and the magistrate with that finding of contempt, and that whenever mother was given a chance in the history of the case, and specifically this case, when she had a chance to restrict father's parenting time, she would do so. The judge also in her decision stated that, once the CPS cases were closed, though maybe in some cases it would have been a good thing to continue restricting the parenting time. In this case, it was not, and that parenting time should have started again, which led to the contempt finding, which, you're correct, there was no monetary. It was almost as if the court either said it was moot or purged because we're going to grant father custody, so there's no sense to do any make-up time. He's going to have the custody with him there. Again, to sum up, and if there's other questions, I understand, but to sum up, the judge did use a very sound, reasonable reasoning process. The magistrate used a sound reasoning process, and the guardian ad litem, in doing her investigation, utilized a sound and reasonable reasoning process, and this court should affirm the judge's decision. Thank you.
Thank you. Mr. Kulik, you have 3.5 minutes.
Thank you, Your Honors. I would like to point to critical aspects of Mr. Anderson's oral arguments. The first is he mentions medical appointments that the mother either withheld from the father or just later on, told them. Mother was the legal custodian at that time, was doing everything in the best interest to provide the medical care to the child, would inform father of medical appointments, and in fact, actually would discuss with father medical concerns that father had, even if the medical professionals that mother was taking the child to didn't have concerns with, and followed up and brought the child to medical appointments to just calm father's concerns that these issues that you say might be happening didn't. One instance of that was a alleged lazy eye of the child. Maybe the child had seeing issues and couldn't see to the best of her ability, and mom took the child to a professional to make sure that that wasn't an issue. So in fact, she was even considering father's concerns, which she didn't legally have to because she was the legal custodian. The one instance of the tonsillectomy, and father wanted to come, there was a misunderstanding, I believe from my client. This was COVID times where they were restricting parents from going, and it was her belief that only one person could be with the child at that time because of the COVID restrictions in hospitals. The second part goes to the sound reasoning process of the judge and initially the magistrate in making its decision. Largely, the decision was based on the second Children's Services investigation that occurred. As a mandatory reporter, Dr. Vicki Reynolds found out through her session with the child that potential abuse was going on, or at least indicated that that might be a concern, and she was mandated to report to Children's Services to investigate further. Mom became aware of that investigation, and she expressed more concerns about overnight parenting time with father, and then did not find out about the investigation until a later date. The court, in its decision, first on page 6 on the top in the first paragraph states that the record is unclear as to whether mother was aware that the allegations reported to Dr. Reynolds were based on the same facts. And then the next paragraph makes a finding that mother was aware that JFS found the allegation of abuse to be unsubstantiated. So essentially, the court is saying that mom, there's no evidence to suggest whether mom knew or not, and then in the next paragraph says she knew, and she denied parenting time unreasonable, and that was a large part of their fact. In the case, mother argues that the second she found out about the investigation being closed, which there's always a lag between when it's actually closed and when a parent knows it's been closed, because Children's Services delays the letters out, and there's always some time period where you don't know. And the second she did know, through her attorney, contacted father to try to resolve the case through a very detailed parenting time schedule that father never responded to, except for a request for discovery, and then we had to go to trial to determine the case. So mother was trying to work it out once she found out about the investigation, and if that was found to be true, based on the facts of the case, that she did find out Once she found out she tried to resolve parenting time with father, then she wouldn't have unreasonably denied, and I believe the court would have made a different decision. Thank you.
Great, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. And just to let everyone know, the first case that we called, the Snyder case, was actually submitted, so that will not be argued today. So that concludes our court today. Thank you.